The broadcast is now starting. All attendees are in listen-only mode.
Thank you for joining us today in this ASPPH Presents webinar series. The subject of today's webinar is opioid litigation and the opportunity to advance public health approaches through a possible master settlement agreement. At the March ASPPH annual meeting, Sam Quiones, author of Dreamland, discussed and documented the role of pharmaceutical companies that manufacture synthetic opioid products in exacerbating America's substance abuse crisis. The human toll of the crisis, an average of well over 100 deaths a day, has been stagnant. Families have been destroyed and the social fabric of communities unraveled. The direct cost to states and local communities has been massive, with billions spent on police and emergency services, healthcare expenditures, and the overwhelming cost of family service agencies. The indirect cost to communities are also costly: lost workers, lost wages, and lost productivity. Over the past year or two, hundreds of states, counties, cities, and Native American tribes have decided to fight back by filing suits against what they view are among the most responsible parties: manufacturers like Purdue Pharma and Johnson & Johnson, distributors like McKesson and Cardinal Health, and pharmacy chains like CVS and Walgreens. Using the tobacco settlement agreement as a model, litigants are seeking both reimbursement for expenditures and broader changes in corporate behavior to reduce the impact of synthetic opioids in exacerbating our substance abuse problem. That latter goal raises the question: what public health interventions and actions by industry would help address the current crisis and also help prevent additional individuals from abusing these drugs? To help us understand this opportunity, we have three terrific experts with us today. As they present, you'll see on the screen a way that you can submit questions. You don't need to wait until the end of their presentations. Feel free to enter questions as we go along, and we'll try to get to as many questions as we can during this session. So our three speakers today, I'll introduce briefly, and then we can go serially through them and hear their presentations without interruption. Our first presenter is Bill Sorrell, who served as Attorney General of Vermont from 1997 to January of 2017. He was originally appointed by Governor Howard Dean, but was then reelected 9 times. He earned his Juris Doctorate from Cornell Law School. Within weeks of taking office as Attorney General, he brought suit against the nation's largest tobacco companies. That lawsuit, along with several others, helped force the historic settlement with the tobacco industry that to date has yielded over $300 million to Vermont taxpayers and continues to provide approximately $25 million a year. He is the former president of the National Association of Attorney Generals, and in 2003 was chosen by his fellow attorney generals to receive the Kelly Wyman Award, which is given annually to the outstanding attorney general. We've asked him to discuss the scope of the litigation, its aims, and how a multi-party settlement might be reached. The next speaker will be Dr. Cheryl Healton, the Dean of the College of Global Public Health at New York University, as well as Director of the NYU Global Institute of Public Health. She's been at NYU since 2012. Before joining NYU, she was the founding president and CEO of the Legacy Foundation, a leading organization dedicated to tobacco control. She worked to further the foundation's mission to build a world where young people reject tobacco and anyone can quit. During her time with Legacy, she guided multiple campaigns to reduce youth smoking, as well as other cessation campaigns. The Legacy Foundation is now known as the Truth Initiative. She has a doctorate from Columbia, where she served numerous roles for many years after after her graduation. And our last speaker will be Dr. Josh Sharfstein, currently the Vice Dean for Public Health Practice and Community Engagement at the Johns Hopkins Bloomberg School of Public Health. He was Secretary of the Maryland Department of Health and Mental Hygiene from 2011 to 2014, and was Principal Deputy Commissioner of the U.S. Food and Drug Administration until he stepped down from that post in 2011. He is also the former health commissioner of Baltimore. He graduated from Harvard Medical School and did his residency in pediatrics. He also spent several years on the staff of the House Government Reform Committee and was a principal health policy advisor to Congressman Henry Waxman. A prolific author, Dr. Sharfstein's book, The Public Health Crisis Survival Guide, Leadership and Management in Trying Times, was released just this month by Oxford University Press. So, Attorney General Sorrell, thank you for joining us, and we look forward to your remarks.
Well, thank you very much. I'm honored to have been asked to participate today and share some thoughts and observations about tobacco-related issues, but particularly about the opioid litigation that's ongoing right now. I first want to be clear that I am not involved in the current litigation. I'm an outsider. I'm not affiliated with any of the private law firms that are involved in various of the lawsuits, but I have talked with a number of folks who are involved in the litigation and interested in the matter, and I think I might have some, hopefully I have some helpful information. As was suggested, I filed the tobacco lawsuit just within a matter of weeks after becoming Attorney General and was involved in the negotiations leading to the master settlement agreement, and then thereafter as chair for several years of the National Association of AG's Tobacco Committee, worked hard with many other states to enforce the master settlement agreement and to put some substance to the bones of the settlement as to really what the provisions meant and what they didn't mean. The current opioid litigation, and I say litigations, but it's really litigations, as has been suggested, there are hundreds of individual defendants that have filed suit already. These are municipalities, counties, I believe it's 32 states, that's close to the number. Other states investigating whether they should file, and various healthcare providers, Native American groups, and such. And these cases have been filed in individual state courts around the country, and also in federal court. And what happens sometimes with federal litigation, when there are similar cases filed in different parts of the country in U.S. district courts or trial level courts within the federal system, a judge sometimes sort of takes over all of the federal cases at the trial level and brings them together into what is called an MDL, or multi-district litigation. And this is what has happened here with a federal trial court judge in the state of Ohio that is the lead judge for the so-called MDL. And he has chosen 3 counties in Ohio to be the lead counties, the lead plaintiffs in moving the litigation along. And the judge has been very aggressive in trying to move the cases along, and in this litigation that is massive, to say the least, with hundreds of plaintiffs in the MDL that he has set some very, very aggressive timelines and has even talked about a trial in the case happening, if not in 2019, then not long into 2020. And this is and would be warp speed for a case of this magnitude. Motions to dismiss the case are to be fully briefed before the judge in Ohio by I believe it's the end of July. And from some statements that he has made, observations of others, it doesn't look like he will take a long, long time to decide on the motions to dismiss. And there are estimates that we might well have answers on the motions to dismiss by the end of this calendar year. And of course, if he wants to hold the parties to a trial in either 2019 or 2020, he's going to have to decide the motions to dismiss promptly. Now, those are the cases that are in the MDL, but I think I've said, and I want to emphasize, that there are a number of related cases or similar cases involving different defendants from the pharmaceutical industry that are in individual state courts around the country and not part of the MDL. And that might be of some significance as these things move along. I should also say that the judge has not just put the case on a fast track towards trial, but he is pushing the parties to negotiate a settlement of an overarching settlement of the hundreds of lawsuits. He has also pushed the states that are not in the MDL. Right now there's only one state that's in this multi-district litigation in front of the federal judge. He's pushed the states that are actively litigating in their own state courts and the states that have not yet filed, which includes some of the largest states in the country, including New York, California, Pennsylvania, have not yet filed suit. So they're in the investigative stage. The states have been resistant or have been concerned about negotiating in the MDL case, afraid that they would be submitting themselves to the jurisdiction of the federal judge and thereby not be able to proceed in their individual state courts with their own lawsuits. The judge has assured the states that they are not submitting, if they involve themselves in negotiations, that they are not submitting themselves to the jurisdiction of the federal court. He has also pushed the Department of Justice and the Drug Enforcement Administration to become involved on the part of the federal government in these settlement negotiations. So there are negotiations going on, but there's a lot of investigation going on, and the states individually, collectively, the other plaintiffs, I am told, have been reaching out to public health interests to try to get good ideas about what they should have in mind. Should there be some accelerated pace of negotiations, hopefully leading to a global settlement, and we'll see. But this issue on the motions to dismiss will be key if the judge, in fact, denies the motions to dismiss. The individual defendants sued in various of the cases will have greater incentives to actively negotiate. So time will tell. We'll see. There's a lot of litigating going on, a lot of plaintiffs, a lot of public entities. The thought of a global settlement is just a monumental thought, but this webinar is very timely to be convened right now and to hear from more in the public health community for good ideas about what the negotiators might consider for inclusion in any settlement discussions. So with that, I'll sit back and listen, and hopefully if there are questions that come to me or something I know about, I'll be happy to try to be of further assistance.
So should I just jump in, Tony? Tony?
Yeah, go ahead, Dr. Healton.
Okay, thank you so much for including me. I'm going to spend just a few short minutes, 10 minutes or so, providing a brief overview of the provisions of the historic MSA tobacco settlement, and then spend a few minutes talking about the barriers that occurred in the actual implementation of the settlement, and then to very quickly talk about what types of provisions would represent analogous provisions, but as Bill pointed out, and I think importantly, the provisions that existed for the tobacco settlement may or may not be provision appropriate ones for the tragic situation we're faced with in terms of opioid deaths and disability at this juncture. So the historic tobacco settlement is now 20 years old. It passed in November 23rd, 1998, involving 46 states, 5 territories, and the 5 largest tobacco companies at the time. The states gave up future claims regarding provisions covered in the settlement, excluding, of course, enforcement of provisions. Individuals can continue to bring claims. The tobacco industry was required to make annual payments in perpetuity to settling states to compensate them for tobacco-related costs incurred. States were free to use the money any way they chose. We'll return to that in a moment. 4 states had settled separately in advance of the 46-state settlement: Mississippi, Texas, Florida, and Minnesota. The MSA is a private agreement. An additional 40 companies have subsequently joined since it occurred, many of them very small companies. They're incentivized to join because they can be sued if they don't join. So one way of relieving themselves of that is to join. $4.5 billion a year in 2000 and $9.5 billion a year in the year 2018, plus bonus statements, bonus payments that also occur as well. So the provisions within this agreement, it prohibited or restricted a number of things. It prohibited the direct and indirect targeting of youth, and that included things like Joe Camel. It prohibited outdoor ads not in direct proximity to tobacco sales outlets. It prohibited product placement in entertainment media. It prohibited the distribution of free samples, branded merchandise. I think notably in relation to the opioid industry, lobbying against particular brands of tobacco, types of tobacco control legislation and administrative rules. Also relevant to opioids, the suppression of health-related research. Also very relevant to opioids, material misinterpretations against the health consequences of using tobacco. In this case, it would be true for patients as well as providers. And importantly, in addition to the large amount of money that flowed to the states to recompense them and which they were free to use in whatever way they chose, it created a national public health foundation, originally known as the MSA Foundation, converted then to the Legacy Foundation and now the Truth Initiative. That foundation has undertaken many tasks over its now nearly 20-year history, but one of its principal tasks has been providing public education to reduce youth initiation of tobacco use. And there are obviously parallels there with respect to opioids, but the educational target would certainly be beyond adolescence. Other provisions were that the industry was required to dismantle the Center for Indoor Air Research, the Tobacco Institute, and the Council for Tobacco Research, and they were also prohibited from creating similar groups. Now, this is very much about, freedom of association, and apropos to Bill's point earlier, in a settlement such as this, people can agree to give up their rights in the same way that the tobacco industry essentially agreed to a warning label on its product, the first Surgeon General's label. But when it came to the graphic warning labels, they decided court was where they wanted to go rather than have to face those warning labels that were as graphic. The settlement also provided for funding to the Center for Tobacco and Public Health at NAG. NAG is the Association of Attorneys General. And notably, as I mentioned, the states were not required to spend any degree of funding on the tobacco problem other than the tithing that went in to create the National Foundation. And as a result, there has been much commentary about how the money was in fact spent, and only 1.5% really has been directly earmarked for tobacco control. So this has been characterized by one organization as the broken promise to our children. The cost of payments to states has largely been passed on to consumers via price increases. And in a moment, when I talk about analogous provisions that might be used with respect to the opioid epidemic, this would be a particularly problematic one because there is a street alternative to synthetic pharmaceutical opioids, which is substantially less expensive than the current drugs on the street, and therefore that type of a provision would have a very strong and negative unintended consequence. I'm just going to briefly describe a few barriers that occurred with respect to the implementation of the MSA. The MSA created two funding streams. One lasted for 5 years and one lasted for 10. Bill Sorrell is very familiar with the term the sunset clause, and so essentially the MSA created a foundation to combat the tobacco industry, and while it was very, very well funded initially and over the first 10 years, at the end of the 10 years, the only revenue it has is whatever it can raise and whatever it earns on its corporate, the money that it has not yet spent. A prohibition on lobbying. The second obstacle was that the MSA prohibited the foundation that was created from lobbying. It also prohibited it from engaging in vilification. Not surprisingly, the foundation ended up in court in order to adjudicate what in fact vilification meant. When it became clear that the foundation was imparting many factual bits of information that were unflattering. In this particular instance, the foundation prevailed, and thanks to Bill Sorrell, especially because he was enormously instrumental as a board member, making certain that that case came out the way we wanted it to come out. And then finally, they lost in all levels of court, including the Delaware Supreme Court. So now very briefly turning to what are the implications for this settlement, for an opioid settlement. Well, first of all, I've mentioned price. This tobacco settlement literally passed on virtually dollar for dollar all of the costs of the settlement to the consumer, and the result was in essence a positive one because it immediately suppressed the smoking level, because there is a very strong correlation between price, inverse relationship between price and use. That would be much more complicated with respect to opioids, and I certainly wouldn't recommend it, and I don't think many others would as well. Then we come to the cost that this epidemic has led to being incurred by the states. Treatment costs, other healthcare costs, social service costs, legal costs, and then the more imponderable human costs of losing so many lives and so many fathers and brothers and sons and daughters to this epidemic, which is costing just on a synthetic opioid and about 64,000 lives a year, which puts it vastly higher than the AIDS epidemic at the zenith of those deaths in this country. And so clearly having a flow of money back to the states to recompense them for lost costs, expenditures that they've made is a great provision to have, but the risk is that the same problem will occur that occurred in the tobacco settlement, and that is that funds will make the states whole, but may not necessarily address the problem. So it's going to be very important to balance those two things in any negotiation that happens. Then labeling and warning is a very complex area because labels on drugs are in fact overseen by the FDA, but one could make a strong case in a settlement that health providers especially and consumers in particular vastly misunderstand the risks associated even with normal use of opioids, let alone use of opioids in a long-term and high-dosing paradigm where the risks are especially high because oxycodone in particular is much stronger than, for example, morphine is, and this particular drug comes in very high doses. What should not happen, and what did happen in the federal litigation against the tobacco industry known as the RICO case, is that the tobacco industry was forced to make public corrective statements. In fact, they just began making them a few months ago after, basically years of negotiating what would be in those statements. I'm not a fan. I don't know what Bill Sorrell's position on this is, but I'm not a fan of the tobacco industry making their own corrective statements. Granted, they had to have a negotiation about what those would be. If it is not illegal for this to happen or regulatorily problematic for it to be possible, I think the pharmaceutical industry should be required to make, not by themselves, but to fund through this settlement, an entity that will make these corrective statements. In terms of advertising restrictions, obviously these products are advertised in a different type of way because of the products that they tend to be advertised through the chain of detail people hired by the pharmaceutical industry going to practices and promoting the use of the drug. And this was done and is outlined for those of you who would like to read it, I think very skillfully in the Delaware AG's filing against the industry, where they describe how the organizations that were funded by the pharmaceutical players in this space sort of created the pain problem. There clearly was a pain management problem. Few would debate that, but it was very much exaggerated, and the groups that were lobbying for greater access and greater ease of access to these drugs were largely funded by the pharmaceutical industry. And as I read about them, they sounded to me very reminiscent of analogous organizations that were funded by the tobacco industry. Finally, as I mentioned, the centerpiece of Legacy and now Truth Initiative is public education to prevent the initiation of tobacco use. And while we have had public education through ONDCP and the Partnership for a Drug-Free America, it only intermittently focused on the issue of opioids, largely in terms of access to the family medicine cabinet. This type of problem that we are now facing requires in my opinion, a mass public education campaign. There are people who debate this issue, but I think it is quite crucial, including one that would reach all health professionals at all levels, so that they understand all of the factors associated with this. And it would be an umbrella campaign with some very targeted campaigns directed toward those who were the focus, most especially of the opioid industry, particularly family practitioners and general practitioners around the country. So that's my summary of the MSA, how it unfolded, and how it would be analogous to an opioid settlement, but of course has been stated, and just to be reiterated, because these are private voluntary settlements, a host of other provisions could be agreed to that are not presently a part of the tobacco settlement. So thank you very much, and I'm looking forward to the rest of the webinar. Thank you.
Great. Thank you, Dr. Healton. I'd like to remind everyone, feel free to submit questions using the question box that should be on the right side of your screen, and we'll try to get to as many of those questions as possible. So now we'll turn it over to Dr. Sharfstein. We welcome your thoughts.
Thank you very much, Tony, and it's great to be on the phone with Bill and Cheryl, who really did so much on tobacco and are real heroes. I work at the Johns Hopkins Bloomberg School of Public Health, and one of the projects that I'm involved in is the American Health Initiative, which puts us out in different cities and states across the country where the leaders are asking what would really make a difference to reduce the opioid epidemic. And maybe my contribution to the discussion will just be to suggest where a settlement could play a particularly helpful role in filling gaps in the current response at different levels. And number one for me would be to address the current harms of the opioid epidemic. And in particular, there are many, many people who became addicted as a result of taking pain medicines, or as a result of the fact that opioid medicines were much more widely available for misuse and have either stayed with an addiction to pills or have moved on to heroin and fentanyl. And there are huge gaps in getting people services that can save their lives, not just in clinical settings, where, but also in non-traditional settings, such as in jails and prisons. There was a paper out of Rhode Island that found a 60% reduction in fatal overdoses when they actually began to treat people in detention who have opioid use disorder with FDA-approved medicines and other treatments. But most, that is not by a long shot the standard in many parts of the country. And even under the Affordable Care Act Medicaid expansion, Medicaid won't pay for treatment right now behind the walls of a jail. So there is an urgent need for a massive investment in corrections, which is a place where people could get started into treatment, not only save their lives, but substantially reduce recidivism. Another area which has been very hard to fund nationally is in the area of harm reduction, people who may not quite be ready for treatment, but can be moved towards treatment and really kept alive through syringe exchange, fentanyl testing, and other kinds of services and peer support, housing, and other things that would really make a difference for them. There are enormous gaps in all around the country in those areas that a settlement could really save a lot of lives by filling. Number two would be prevention, and prevention by really improving the problem that existed around prescribing. And I would say in this area, there's a lot of activity that's going on. Already there are many new professional standards. There's been a 30% decline in opioid prescribing over the last 7 or 8 years. But there are still problems. And one of the problems has been whenever there's a new opioid approved, there's this enormous continued need for the company to aggressively promote it, and there have been continued guilty pleas and other problems there, and to the point that you could have a settlement that actually allows people to give up some rights in exchange for the settlement. The idea that you could really create a different way of marketing opioids to physicians and to patients, and basically back off a whole bunch of tools that may be a little bit more understandable if it's for a new antihypertensive medicine, but certainly poses a lot of risks for a new opioid. And there have been so many problems in the marketing over time, it doesn't really make sense to just continue to have these massive legal cases brought against the opioid manufacturers if you could prevent them by just having a different standard of marketing that maybe would be difficult to legislate, but somebody could actually agree to. I think there are other gaps, particularly around education of physicians and training programs that could be filled, of course, through an intermediary with support from the industry that could really help reset the medical profession's approach to opioid prescribing in a way that is still thoughtful. And then the third, I would just, I'm not as enthusiastic as just writing a check to cities and states for the costs that they've incurred, although I understand they have been great. I do think that the challenge is that there is a raging epidemic still, and in many places the number of deaths is increasing. And if you don't invest in actually calming that epidemic, then just paying for past expenses isn't going to be helpful very much, because you're just going to be paying them again as the problem keeps getting worse. So I do think it's very important that the funding be used directly related to the opioid crisis in treatment or prevention. One last comment on the idea of a public communications campaign. I think it's important to broaden this concept beyond just the need for opioids in pain. I would say for the need for opioids when managing pain. There is such an important issue for so many people who've been affected by this that the stigma of the addiction has made it very hard for people to turn to treatment. And the addiction has led to so many people not just losing their lives, but losing all their connections to their loved ones and their family and their communities. And I would think that a real opportunity would be to support a genuine campaign that isn't just about, you may not need 5 days of opioids after your tooth comes out, but really be about what addiction is, which is a chronic brain disease, and that there are appropriate ways to handle addiction that actually helps people to regain control over their lives, and the outcomes can be quite good. And also destigmatizing the use of medicines for addiction treatment because they can be so effective. So I think there's enormous opportunities in these areas to really pay for things that are not going on now, despite the fact that the opioid epidemic has been reducing the life expectancy in the United States. So maybe I'll just stop there. I will say one other thing, just really quickly. I think the point that Cheryl made is very interesting about how this gets paid for. I think it's a very complicated issue, and I've just started to think about it. I'm not maybe quite as concerned about having the companies pay for it, that they would pass the cost on, in part because they have so much funding, and in part because of the role insurers play. So I think I totally take Dr. Hilton's point that this is something that is worth thinking about, but I'm not immediately at the point that it would be a bad idea to have them pay a lot of money to do this, because I think they've caused such harm, they've reaped all these benefits, and there are real opportunities to save lives with the right investment. Thank you.
Great. Thank you, Dr. Sharfstein, and thank all three of you. Terrific presentations. I'd remind everyone, if they would like to submit a question, to please use the online question submission tool that's on the right side of your screen. We do have a couple of questions. The first one is how important, and I'll throw these out and let anyone who feels like they have something to contribute to take them on, but how important is it that the federal government become a party to the litigation? In addition to controlling labeling, the Food and Drug Administration largely controls the advertising of ethical drugs. And would one be able to put restrictions on both labeling and advertising without the federal government, specifically the FDA, being a party to a settlement? So I welcome your thoughts on that question.
This is Bill Sorrell. It would be a much better situation if the federal authorities are part of any settlement that is reached. If the federal authorities are out, there are issues of federal preemption that could enter into the mix, where even if the parties, the pharmaceutical industry and the plaintiffs, wanted certain actions or statements to be made, there could be arguments that the federal government has preempted this or that area of labeling. So it'd be much better that they be in there. I will say from the state's perspective that we're talking politics, and the pharmaceutical industry, just as the tobacco industry was and remains, is in terms of how much they spend in lobbying in DC, their profound influence there. And states historically have been concerned that corporate involvement in these issues, when the feds are in and have a prominent place at the table, that the states as laboratories of democracy sometimes can't go as far as they want to when the feds are in and listen more closely to industry perspectives. But I think that overall, a settlement, if a settlement could be reached, would be preferable to having an individual judge hand down a decision even in the MDL case, because there will still be all of these other cases. It'll be a very much of a piecemeal kind of solution to a national problem. And if there is going to be a settlement, it would be great if the feds are very actively involved.
Great. Dr. Healton, Dr. Sharfstein, do you have anything to add to that?
I agree.
Okay, great. If not, the next question is, in what ways are physicians or prescribers responsible for managing opioid addiction? Are there policies in place that are restricting excessive prescribing and patient education in non-medical pain management? I guess I'd add to that, to what extent could a settlement agreement affect prescribing authority of physicians? Is there any way to help control or force the education of prescribers?
This is Cheryl Healton. I'll jump in just a little bit on that one. I did get disconnected, so one question is, can I be heard?
Yes.
Okay, good. So just to make one clarification, when I was saying that I did not think the cost of the settlement should be directly passed on to the consumer, my concern was solely in relation to what it might do to the direct purchase price for the consumer. I do believe that the cost should be borne by the pharmaceutical industry, but I don't think that they should oversee any form of education personally. I think it should be put in the hands of a third party. So if I was not clear, I apologize. I just want to make one important observation. I've had a lot of conversations with providers, as I'm sure Josh has as well, and there are totally disheartened general practitioners and providers from other subspecialties out there who now have fairly substantial numbers of addicted patients that they were simply treating for chronic pain, and they genuinely believed that this particular formulation was much less likely to addict their patients, and now they are in quite a quandary. So I think the points that Dr. Sharfstein was making earlier about how very important it will be to have a whole range of services that encourage providers to identify people with this problem, to assist them getting into treatment, whether it's through them or through others, training people up to provide the treatment, and most importantly, destigmatize this, because so many people are addicted. It's, in a sense, the deaths are the tip of the iceberg, and beneath the line are all the people who are struggling with addiction but have not yet died from it. So we have an enormous public health problem, and the only way that we can really address it is to rally everyone around it with a very substantial amount of resources put behind it.
Great.
And I agree completely, and this is Josh. I would just jump in to say that there are a lot of things that you could imagine a settlement doing to help with prescribing. You could imagine supporting training programs for people to really be there to help primary care doctors manage patients who are now on high doses of opioids and may be not even feeling that much pain benefit, but who are really terrified of coming down on the doses. They may be able to support research to figure out some of the really tricky questions of management. And I think just more in general, I think the idea that a settlement could support research to make sure that the types of initiatives are having their intended effects, and that particularly the clinical initiatives are not having unintended effects that could be dangerous for patients. So I think we could probably rattle off a whole bunch of them. It probably isn't, though, like, they're going to come to a settlement with the manufacturers that the products can only be prescribed for 1 day at a time. I'm guessing that the medical boards and the state legislatures and the FDA probably wouldn't want that to be, would see that as what they're responsible for. But even having said that, I think that there are a lot of things that could be done to figure out the right way to handle some of these clinical situations and support programs, quality assurance initiatives, and other things that would really reset clinical practice again.
Great. So another question is, given the innumerable federal and state lawsuits, one of the reasons defendants are interested in a master settlement agreement and participating in the process is that it gives them both financial certainty as well as certainty about future business practices. Is the spread of federal and state litigation an impediment for defendants coming to the table and helping negotiate a realistic settlement agreement?
I'll jump in here just to say that the headaches for the defendants are monumental here. And what's one of the things that's different in the opioid litigation than the tobacco litigation was in tobacco, there were, just the major companies, the big four, whatever had, like 99% of the marketplace. And so you had relatively few defendants. And then you didn't have all of the plaintiffs, and that you had the states, but you didn't have all the counties and municipalities and such. And so in the opioids situation, where you have so many different defendants in some sued in multiple cases, others just sued in a few cases, that a settlement, a global settlement that sort of is an all-in resolution of these issues, I got to believe that the industry from A to Z would prefer that. Obviously, the greater number of plaintiffs and the greater number of defendants, the challenges of herding the cats into a settlement are daunting, but I don't think that should prevent it from happening. The states, municipalities, and counties are not going to want to have to go through individual trials with millions and millions of pages of documents and such, and lengthy litigation. Courts are not going to want to hear too many of these trials, and the industry would rather get back to business and not be paying billions of dollars to lawyers.
Terrific. Another question we received, legally speaking, what would be the mechanisms for ensuring that states spend settlement money on prevention and treatment? Can this be done through a settlement, or would it subsequently be up to each state legislature?
I don't mean to monopolize, but in our system of government at the state level, you have three independent co-equal branches between the legislative, the executive, and the executive branch, the legislative branch, and the judicial branches. And legislative branches and governors have not wanted attorneys general tying their hands on how money is spent. And the states that in their settlements tried to do it and tie up how settlement monies in tobacco were going to be used were in some cases sued successfully by state governors who had other priorities for use of the funds, and for litigation that for the executive branch to intrude on the province of the legislative branches by deciding how money gets spent is an unconstitutional action by AGs. So it's a tall order for the settlement of a lawsuit to ordain forever how ongoing funds are going to be spent. As Cheryl said, the tobacco case, the payments are to be in perpetuity as long as the industry is in business. We don't know what a settlement of the opioids litigation would look like, and nor the funding stream, and would it be in perpetuity or whatever. Those are all open questions. But to say that just simply you can say that all the money is going to be used for public health forever that comes from this settlement, it's easier said than done legally and constitutionally.
Great. Cheryl, do you have any additional thoughts on that?
Well, Bill may remember, he and I have had this discussion a few times in the past, and I tend to think that if you had a settlement where a part of the settlement, and a very substantial part, I'm just going to make up a number, 60% of the money, was to recompense for costs incurred by states, and 40% was to build new programs to ameliorate the epidemic going forward. I would suspect, if it was a state settlement, that there may be ways to negotiate it on a case-by-case basis. But I do agree with the basic point that Bill is making, and who would I be to disagree, because I'm not a lawyer in the situation in the way Bill has been. But I do think there is a threshold where the states would walk away, but there's a point where they would be so financially incentivized to participate that they might set a principle aside for this unusual epidemic.
That's a very good point by Cheryl, and I would, despite my reservations that I expressed, I'm not saying it shouldn't be tried.
Exactly.
It's a worthy effort, and they should push in the settlement to tie as much money up for as long as possible for purposes to be spent for public health. That should be a strong effort in any successful negotiations.
And I would just add that one way to do that would be to associate the expenditures to the size of the epidemic and to allow money to flow back to other purposes as the epidemic is brought under control, and then maybe even reserve funds in the event that the epidemic were to reemerge.
If I could do a follow-up question to you two, I wonder, given the experience that you had with the tobacco settlement, you think that there's a way that this settlement could be framed politically, small p politically, it would make it less likely for people to, at least in the early years, to be able to divert money. I mean, I'm not sure people realize just how little money would go for tobacco control before, but is there a way to set standards, benchmarks, have it really be a core part of the commitment people are making that would make it much harder for states to turn away from that, setting aside the legal requirements?
Well, one obvious way, and the precedent is set within the MSA, is the creation of an independent foundation that could be the National Foundation to, combat opioid morbidity and mortality. I mean, that's not a good name, but you could theoretically argue that a third of all resources would go into that, because if everyone agreed to that, as they did in this particular instance, and it was a very late emerging element, it did happen. And so that would be one mechanism for which there's a precedent.
Well, and you could use that to fund treatment and all the other things we're talking about, right?
That's right.
You wouldn't have to just do a communications campaign that way. You could just say the money's going to go here, and
nor did Legacy. Right. It made program grants to states. It did research. It did many, many things. Not just. It probably spent about 65% of its resources on public education and 35% on other things, including that's a great point. Over 90 million in grants to other organizations, including states.
So that would be like a rock solid guarantee that the money is going to be spent as intended.
Except that, and I think Bill makes a good point, there'll be a lot of pushback on that. And one question I would throw out, just because I think it's a nuance in all of this, Bill, what do you think is the possibility with these hundreds of cases queued up that the AGs will say, we think we'll just do our own settlement, thank you very much, which I think has some advantages and probably some disadvantages I'm not seeing.
Well, certainly a challenge to a global settlement of the hundreds of cases is the fact that there are so many more plaintiffs now, and these hundreds of municipalities and counties that have already filed suit, they're expecting cash out of this, and some of them might want to use it all for public health. Others might want to, roads and bridges or whatever, but they are, I think many have looked at the tobacco settlement as saying, hey, we sort of got cut out of that, and it was done at the state level, and that's in part why municipalities and counties have been much more aggressive in filing the cases, and it will be difficult to come up with a settlement that's satisfactory to them if they don't. There's going to be a lot of folks wanting pieces of a settlement pie. It doesn't mean it's impossible, but it's going to be much more daunting than it was for the settlement, the global settlement of the tobacco litigation.
We have, and we might make this the last question because it's appropriate as a last question, and I'll direct it to Dr. Healton. How are the various state attorney generals and other claimants gaining and receiving input from public health about the potential settlement provisions. What would you recommend for public health professionals who want to make suggestions of public health interventions that might be included as part of a settlement agreement?
Well, let me just preface this by saying I know through conversations with people who have been consulted that some consultations are taking place, but I do not think that they've reached the systematic outreach phase. At some point, and I don't know when that point would be, and I would ask Bill to advise us on that. It's the sweet spot for getting that information before people. It may be now, it may be later in the proceedings. I do think that there should be systematic outreach to public health professionals, particularly state and local health commissioners, as well as, frankly, academicians that have dedicated their career to particularly the policy aspects, but also to treatment aspects related to pain, and those would generally be obviously outside of schools of public health. And I mean, I do think that there will be a very substantial adjudication of the science of pain relief, because this is not my area of expertise, but I had a recent conversation, and I think the person who was giving this information is very well read on this subject.
Great, thank you. Mr. Sorrell, did you have anything to add to that, or Dr. Sharfstein? Well, if not, I'll thank you all for participating.
Well, I just wanted to say that I think the public health community shouldn't wait to be asked. The states feel like they are seeking input from the public health community, but public health folks should be aggressive in trying to get their messages and their thoughts before the private attorneys and the AGs and others. And I much encourage, don't wait to be asked, be aggressive now with adding your best thoughts so that they can be considered by those in the negotiations.
Great, thank you, Mr. Sorrell, that's great advice.
That makes sense to me.
Great. So I'd like to thank.
Great, thank you.
I'd like to thank Mr. Sorrell and Drs. Healton and Sharfstein for participating in today's webinar. It was incredibly informative, and we're very grateful. This webinar has been recorded and will be available on the webinar event page of the ASPPH website very soon. We have a couple of more webinars that we'd like to bring to your attention that are coming up in the weeks ahead. On June 27th, there'll be a webinar on student services and holistic admissions. And then on August 7th, there'll be one on policy advocacy and the missions of academic public health. So I'd like to thank everyone for listening in and participating. And I'd like to give special thanks to my colleague, Sarah Weiner, for helping organize the technical aspects of today's webinar. So thank you very much and have a great day.